Good morning, everybody. I hope you can hear me. Good morning and welcome everybody to this state aid seminar. Apologies for the small delay, but we had to fix some technical issues here in front so that you could also watch the slides. My name is Pascal Boymans. I'm a head of unit in DG Regional Policy, and I will be your moderator today and will guide you through the whole day of the program. So I will come back at several moments during the day. We have here in the room about participants, over 90 participants coming from about 21 member states, discussing state aid issues, but always within the framework of regional policy, how it's important to implement it. And I also want a special welcome to our colleagues from DG Competition and DG Regio and Professor Nicolaides from the Collège d'Europe, who will be one of the main speakers today. This seminar is not a standalone seminar. It's not a single initiative what we have taken, but it's part of a wider framework which we have set up between DG Regio and DG Competition, and which we have put up together a common state aid action plan in order to raise awareness, to raise know-how, and to raise know-how about the consequences of state aid for regional policy. And why are we doing this? Why do we think this is important? Well, first of all, as you might know, state aid is one of the main sources for irregularities and for financial corrections for the structural funds. And certainly the share of state aid in the total number of irregularities is not decreasing. So we think it's important that we have right knowledge in order to bring down the number of irregularities. Secondly, with the introduction of the modernization of the state aid package in 2014, the state aid rules offer the possibility to become more tailor-made, and it offers a lot of opportunities and flexibility for member states and regions to apply more tailor-made state aid schemes. But at the same time, it requires also more know-how and expertise to apply the rules correctly. So we also want to use this opportunity to explain the new rules of the modernization of the state aid package. And finally, as you all know, under the 2014-2020 programs, we have a stronger focus on jobs and growth, so a stronger focus on more innovative projects, also a stronger focus on support to SMEs, research and development. So the total share of projects funded by the structural funds, by the ESIF funds, affected by state aid is also increasing. So those are the three main reasons why we've set up the state aid action plan together with DG Competition. And under the State Aid Action Plan, we have different initiatives. We have seminars like this, these very much topical, thematic seminars. And this is the third one. We had one on research and development in January, one on energy in June, and we will have one on transport on the 1st of December this year. And where we really want to bring together state aid experts and people working on the structural funds, but really with quite already a lot of basic know-how of how the rules work. Next to this, we will also start organizing more, let's say, if I can put it like that, more basic trainings on state aid, together with the European Institute for Public Administration. And these will take place in November and December. And I will come back to that later on. But we also invite people like you, but also especially your colleagues, to participate in these trainings. And also we started by organizing state aid seminars in those countries which did not fulfill the ex-ante conditionality on state aid. So we did this last year in Croatia, Czech Republic, Slovakia, Romania, and also Bulgaria. Although Bulgaria fulfilled the ex-ante conditionality, but even there was a specific request. So that's to give you a bit more the background. This is not a single initiative, but it's part of this wider framework within the State Aid Action Plan. Today we will focus on regional aid and state aid for small and medium-sized enterprises. And we will go through the program in the same setup as in previous seminars. We have actually three main blocks. In the first block, where our next speakers will start to speak about, we set the framework. We explain again the basic rules, and we will how the rules work for regional aid and state aid for small and medium-sized enterprises. And we will also already immediately go into what are the key challenges here. In the second block, we will answer all the questions which you have submitted to us in advance, and where we try to be already a bit more tailor-made, going into detail in the specific questions you have asked, and where we will prepare the answers together with you. And the third block, after the lunch, we will start discussing case studies in 3 different workshops. So you have been registered for different workshops, and we'll come back later on how it's organized. But the idea is that throughout the day we expect active participation from you, but even it should become more and more interactive throughout the day, and especially during the workshops, it's especially up to you to ask the questions, make your comments, and share also the daily problems you're confronted with and see how you can solve them. So I really would encourage you to use the opportunity, ask questions, make comments, which makes it also as interesting for us and also make it as much as tailor-made for you. So having said this, well, also finally, the seminar will also be web streamed. So for those people who could not join and come here today, they can still follow it from behind their computer. And I would like to ask you within that context, when you ask questions or make comments, to use the microphone so that we can also, the people watching it via web streaming can also follow the discussion. So this is everything I wanted to say for the introduction. As I said before, I will come back to you during the day during the different parts. So now we start with the first block, and where our first speaker will be Klaus Junginger-Dietl. He's a long-time expert in DG competition on regional aid and state aid for small and medium-sized enterprises, and he will sketch for us the framework for these two areas and what are the main rules of the game in these two areas. Klaus, if I can give you the floor.
That the micro works and that you can hear me at the end. Is it okay? Can you hear me? No.
I think you have to speak it on. It's fine.
It's fine?
I just think you have to speak.
Yeah, okay. Can you hear me now? Okay, thank you. Okay. Support to regional development and support to the development of SMEs has always been a key priority of the structural funds since the beginnings in 1973 or 74. DG Comp duly ensured that all these measures were notified, assessed, and approved by the Commission for a very long time. For a very long period of time. By doing this, DG Comp and DG Regio walked hand in hand, frequently stepping on each other's feet. This had to end, and in 1998, the Council adopted the Enable regulation that allows the Commission then to adopt exemption regulations, which allowed member states to put measures into place that do no longer need to be notified to the Commission. The first exemption regulation, the SME exemption regulation of 2001, exempted already regional aid to SMEs and SME aid. The regional block exemption regulation of 2006 exempted all regional aid. The general block exemption regulation of 2008 laid a broad basis for exemption of mainly all SME relevant measures I'm talking about today. The GBA 2014 mainly consolidated these previous steps into one text. The GBA 2014 for regional aid and for SME aid is mainly a simple reconduction. New elements are relatively few. They concern the limitation of the access of large undertakings to regional aid in sea areas, which are excluded from the scope of the GBA. They include anti-relocation provisions for regional aid, and they include a reorganization of the rules for start-up aid that became a general measure instead of a regionalized measure as in the past. More important changes relate mainly to the measures outside the framework in the region aid guidelines. And the common assessment principles that were introduced by the stated modernization plan. I'm not going to talk about the region aid guidelines and their provisions in detail. We have had only 2 notifications of investment aid schemes under the region aid guidelines and 3 notifications of individual aid. It would be a waste of time, I think, to go into this here in the presentation in detail. I will rather present the key articles in the GBA, Articles 13 and 14 for regional aid, Article 17 for investment aid to SMEs, and the rule for the participation of rules for aid to SMEs for participations in fairs, for consultancy aid, for cooperation in the European Territorial Cooperation Network, and for aid for startups. I'm not going to talk about venture capital risk finance measures. That should be the subject of a different presentation. My presentation will refer only to the rules that apply as from the 1st of July 2014 until the end of 2020, with a reconduction for certain measures until June 2021. And I will discuss the main contents of Chapter 1 and Chapter 3 of the GBA. Chapter 1 are the common provisions. Chapter 3 contains the measure-specific provisions that apply to the different rules. I do not go into Chapter 2, which deals with monitoring, reporting provisions. I do not go into the definition of SMEs, which will be a subject of a workshop this afternoon. And as I said, I do not go into the Region 8 provisions in detail. Under the GBA, aid schemes, individual aid under aid schemes, and ad hoc aid is exempted if all provisions in Chapter 1, the common provisions, and the relevant measure-specific conditions in Chapter 3 are fulfilled. If any of these conditions is not fulfilled, the aid is subject to notification and has to be assessed based on a notification. There exist only guidelines for regional aid. For the other aid measures, no guidelines exist, and assessment would have to take place in direct application of the treaty. I will start with the special provisions that are organized around questions like which types of projects are eligible, what are the eligible firms, what are the eligible regions, what aid intensities apply, what maximum aid amounts apply, what forms of aid can be approved, are allowable, what are is aid allowed as a scheme only, or can also ad hoc aid be granted, what other conditions apply, for example, regarding own contributions of the aid beneficiary, the maintenance of projects in a region, in an undertaking, and similar things. Let's go first to the eligible projects, firms, and regions. I think I don't have to go into detail here. Aid for SME investments, SME consultancy, SME participations in fairs, aid for startups is principally available for projects worldwide. Regional aid is available only for projects in assisted regions. Large firms are eligible only in assisted areas and for regional aid. And investment aid, whether for SMEs under the SME article or under the Region 8 provisions, has to address initial investments for large undertakings in sea areas, initial investments for new economic activities. I'm not going to discuss these definitions now. I think Professor Irregularity will raise some issues regarding them in his presentation. Let's go to the eligible forms of aid, maximum aid intensities. This all is also quite straightforward. Except for startup aid, all aid has to be granted in a transparent form of aid. Startup aid can only be granted in the context of schemes. For regional aid, the Region 8 ceilings apply, which are defined in the Region 8 map. differentiated for large undertakings, medium-sized firms and small firms. For SME investment aid, the aid intensities are 10 and 20% for medium-sized and small firms. For the other types of aid, except startup aid, a general aid intensity ceiling of 50% applies. For startup aid, variable conditions have to be respected. They depend on the duration of a loan or a guarantee. They depend on the type of intervention, which could be a loan, a guarantee, or outright grant. They depend on the innovativeness of the firm and similar elements. And of course, the status of the region. Let's go to the eligible expenditure for regional investment aid. For investment aid, eligible expenditure is defined as either investment costs in tangible and intangible assets, or the estimated wage costs arising from net job creation as a result of the investment that will be incurred over a 2 years period. These two eligible expenditures can be combined up to the maximum of one of these two. Under region aid rules, assets have to be normally new, except for SMEs, except for the acquisition of assets. In the case of the acquisition of an establishment that would otherwise have closed down or closed down already. Additional posts created by an investment have to be filled within 3 years after the completion of the investment. And specific rules apply for the leasing of tangible investment assets, for the acquisition of assets, of closed or closing establishments, for intangible assets, and what is new, for initial investment projects in the form of the fundamental change of a production process or the form of a diversification of the output of an existing establishment. The eligible expenditure for SME and investment aid is either or both of the investment costs in tangible and intangible assets and the estimated wage costs arising from the net job creation as a result of the investment. This is a difference to the rule under regional investment aid, since here both components can be combined and there is no limitation in the combination. That would have been spelled out explicitly in the General Public Exemption Regulation. There are specific rules regarding the acquisition of assets of a closed or closing establishment, including specific rules in case this establishment is taken over by a member of the family or by an employee of the old firm. There are the same rules for intangible assets, and again, jobs have to be filled within 3 years after completion of the investment. For the other investment, for the other SME measures, the GBER defines the eligible expenditure for consultancy aid as a cost for external consultants for non-continuous and ad hoc consultancy activities. For the SME participation in fairs, the eligible costs are all costs incurred for the renting, setting up and running a stand in an exposition. For European territorial cooperation, it's a whole set of organization cooperation, advisory, consultancy, and similar costs, insofar as they are directly linked to the cooperation project. For startup aid, no eligible expenditure is defined. The maintenance and own contribution requirements apply mainly to regional investment aid. or to regional investment aid. Under the regional aid rules, an investment has to be maintained in the assisted area for a minimum period of 5 years after completion of the investment. This period is reduced to 3 years for SMEs. If the eligible expenditure was defined in wage costs, the jobs created by the investment have to be maintained for a period of 5 or 3 years. And the aid beneficiary has to make available for the financing of the investment project an own contribution of 25%, which has to be free of public support. These all are rules that did not really change over the last 15, 20 years. For SME investment aid, the maintenance of the employment directly created by the investment for a period of 3 years is required. And for the other measures, no specific rules as to the own contribution of the aid beneficiary apply. Let me come now to the common provisions that are organized in Chapter 1 of the GIBA. We have here the exclusions from the scope of the GIBA in Article 1, the notification thresholds in Article 4, transparency requirements as to the form of the measure in Article 5, incentive effect rules in 6, aid intensity and eligible cost rules in Article 7, cumulation rules in Article 9, and publication requirements in Article 9. All these provisions have to be respected in order for a measure to benefit from the GIBA. Any deviation leads to a violation of the standstill clause and would require a notification. I will not go into the exclusions from the scope of the GIBA. You all know that large schemes had to be subject to an ex-ante evaluation plan if they were to be exempted for a period longer than 6 months. We have the traditional rules for export aid, for sensitive sectors, the Deckendorf rule, exclusion of firms in difficulties, and similar. The individual notification thresholds, I think, are also quite straightforward. They are defined in terms of maximum aid amounts. For regional aid, a rather complex formula applies. For the other types of aid, we discuss here, the rules are defined in absolute amounts. For start-up aid, variable conditions apply. I should perhaps mention that for regional investment aid, the thresholds are not the only reason why notification might be necessary. A notification might be necessary in case a sectoral aid scheme is applied. A notification of an individual case of application of a scheme is necessary where there is a risk that the aid leads to the relocation of activities from another state in the European Economic Area. And some measures that are excluded from the scope of the GIBA can still be approved under the regional aid guidelines. Here I refer to measures that could be eligible as they involve new products or new process innovations. Let's come to the transparency requirements, which concern the form of the aid. Under the rules, only transparent forms of aid can be block exempted. The GIBA contains a list of types of measures that are considered to be transparent. These are grants and interest rate subsidies, loans, if calculated on the basis of the reference rate communication, but subordinated loans are excluded. Guarantees are included if they follow safe harbor rules, or if the aid element of the guarantee is established on the basis of a methodology approved ex ante by the Commission. Tax advantages can be considered to be a transparent form of aid if they are kept with regard to eligible expenditure. There are specific rules on repayable advances that play only a limited role here. The sale of assets below market price is not a transparent form of aid at this stage. There are plans to change this rule in the review, on the oncoming review of the General Block Exemption Regulation. Let's come to the incentive effect requirements for automatic fiscal aid schemes. Automatic fiscal aid schemes are schemes where the aid beneficiary has a legal entitlement to benefit from fiscal aid, from fiscal advantages, if certain objective conditions are met. There is no discretionary decision of the state on this aid possible. For all these measures of automatic fiscal aid, the incentive effect requirement is considered to be fulfilled if the respective tax law was adopted before the project is started, which means that also all implementing rules for the tax measure have to be adopted before the start of works on the project. This rule does not apply to successor schemes to existing fiscal rules, where it is assumed that continuity will apply. For start-up aid, no specific rule as to the incentive effect applies for start-up aid. It's considered that the incentive effect rule is always respected. Now let's come to the incentive effect requirements for discretionary aid schemes. There are two remarks. We have rules for automatic fiscal aid schemes and we have rules for discretionary aid schemes. We have no rules for automatic non-fiscal aid schemes, which means aid schemes where, for example, a legal entitlement exists to benefit of a certain aid amount if objective conditions are met, but where the aid measure is not a fiscal aid measure. This is an area which is not covered by the GBA. So far we consider that these measures can be assimilated to automatic fiscal aid measures, but it is not covered by the text of the GBA. For discretionary aid schemes, the only condition that is relevant is that the aid application must be introduced before the start of works. I think we are going to discuss the notion of start of works later in the presentation. And the aid application which is introduced to apply for the aid has to be in writing and has to contain certain minimum elements that are specified in the GBA. For start-up aid, again, no rules apply. It gets a bit more complicated for incentive effect provisions for ad hoc aid, which means aid outside of schemes. There again, the aid application has to be introduced before start of works, and for large firms, for regional aid, the member states has to put into place a mechanism that allows him to verify that without the aid, the project would not have been carried out, since it would not have been viable without the aid, or that it would have been carried out elsewhere, since the project would have been more viable in another place. Again, no provision for start-up aid. I think I can more or less skip the calculation rules for aid intensities and eligible expenditure. Maybe the first bullet point should be mentioned. Eligible costs are to be supported by clear, specific, and documentary evidence, which of course puts into question everything about simplified cost approach under the structural funds. That's why this specific condition is being reviewed in the oncoming review of the GBER to allow for the inclusion of simplified cost approaches. What is also going to be amended in the future, most likely, is the last bullet point, which regards the interest rate to be applied to the discounting of aid, where we said so far that for tax advantages that are paid out over a long period of time, so discounting has to take place at the discount rate that is in force at the date the tranche is paid out. This is going to be harmonized. Everything will be now discounted to the aid values at the date of the granting of the aid. Cumulation control, again, is relatively straightforward. The key purpose is to ensure that the individual notification thresholds, the maximum aid amounts or maximum aid intensities are not exceeded by a combination of support measures. Then we have specific rules that explain how cumulation rules have to be done in case we have no overlapping eligible expenditure, in case we have overlapping eligible expenditure, and in cases where no eligible expenditure is defined. I will not go into this since we have to cut a bit on time, I think. Only one mention, start-up aid can be combined with any other aid. Now I come to Article 9 of the GBER, which offers a wide flexibility in its interpretation. It's not very clear in my view in the deadlines it requires to be fulfilled. What is clear is that for a measure to be able to benefit from block exemption, whether it's ad hoc aid, whether it's a scheme, or whether it's an individual aid award, certain publication obligations come in. There is a summary information of all exempted measures that has to take place. The summary information sheet has to be communicated to the Commission, but it also has to be published on a website of the member state or of the region concerned. It is possible not to publish the summary information sheet, but a link to another website that contains the summary information sheet. Similarly, all texts of aid measures, full texts, have to be published somewhere. And third, for larger aid amounts above 500,000 euros, a detailed information on the individual aid granted has to be published. There are specific deadlines that are defined in Article 9. Basically, these requirements all entered into force, practically entered into force on the 1st of July 2016. For most publications, member states have a period of 6 months to implement them. I think it's very important to underline that this is a condition for exemption and that a violation of these publication rules here leads to a situation where aid is unlawful. When I look back into the period 2008 to 2014, my impression is that most member states did not take very serious the publication obligations and the deadlines incurred. I know one member state who failed to submit information for 20, 30 major aid cases for more than 1 to 2 years. All these measures are de facto unlawful aid. You have to be very careful in respecting these rules. This is also underlined by a very recent preliminary ruling of the European Court of Justice in the Delhi's Wellness Hotel case, where the European Court of Justice looked into the question of whether certain requirements of the GBER are of purely formal nature or whether they are mandatory and substantive. And the European Court of Justice concluded that all these measures, including the publication requirements, are mandatory and have to be fulfilled since they are substantive rules. I think this is very, very important to take into account. Within 3 weeks after this ruling was published, we had the first complainants addressing the Commission, asking them to take action against certain aid cases where publication obligations in the past had not been fulfilled in time. So this can become very, very serious. I think the key change over the last 5 to 10 years is not only the change in the conditions of the general work exemption regulation and of the rules, but also a significant change in the environment under which we all are working. Between 1973 and 2000, it was more or less an interaction between Commission and Member States. There were very few competitors that introduced complaints. National courts were normally not involved. Life was quite easy, in particular also as auditing authorities had not yet discovered the interest of state aid rules in their actions. Now I think the rules have fundamentally changed. The Commission's rule is mainly limited to adopt block exemptions following advice by member states and advisory committees. It's mainly the responsibility of member states to do the implementation. The Commission can give guidance, but real interpretation can only come from the European courts if necessary. Everything else is a bit in a difficult gray zone until a clear interpretation of rules that can lead to misunderstandings is established. Okay, thank you very much for your attention. I think we have many more questions to come. I have to admit that when I looked into this GBER in preparation for this presentation more in detail, I felt a bit like James Cook, Captain James Cook, discovering the South Seas. I saw many nice islands, but I encountered also many, many reefs, and it's very, very difficult to charter all the reefs. And I think one of the tasks of this seminar today is to identify some of the key reefs that might create shipwreck and to try to find solutions how to deal with them. Thank you.
Thank you, Klaus, for taking us on this sailing tour through regional aid guidelines and support to SMEs, and giving us a framework and setting the framework for the rest of the discussion of today. And of course, you couldn't go into every detail, but those detailed questions can always come back in the workshops later on. What I kept from your presentation is also that the GBER is certainly not something fixed. It's also being reviewed on a regular basis, and I also understood there are some changes planned for modifications. So we also might hear maybe a bit more later about that. So now I would like to hand over to Professor Fedor Nicolaides from the Collège d'Europe. You can stay. I think he has to see the slides. Okay. I have to go there. Okay. Yeah, you're right. We will look at the framework a bit more from an outsider and really identifies what are the main bottlenecks and challenges we are confronted with right now. Please, the floor is yours.
Thank you very much. And many thanks again for inviting me to this event. Like previous events, I will indeed say that I'm an outsider, so I will not pretend that I know the ins and outs. But as in previous events, my task was to bring in my own experience in working with public authorities and sometimes with either complainants or the recipients of aid who read the GBR, read it again, and they did feel like explorers navigating around shallow shores. So what I propose to do over the next 15-20 minutes is to look at the what member states are doing. I'm sure each one of you knows what your country is doing, but I want to cast it in the broader framework of the European Union. So I'm going to look at, I will start by looking at the numbers and what member states tell the Commission they are doing. And then I will look very quickly at the European Court of Auditors reports. Klaus Otto mentioned auditors, and I think that is an excellent reference to the fact that you will all be audited at some point in time. And the reports compiled by either the special reports or the annual report of the Court of Auditors does refer to a number of issues that, if you go back a number of years, you will see them appearing again and again and again in the reports. So it must mean that these are the typical measures, or the typical issues where member states, as I wrote there, appear to be getting it wrong. Then I would look at some of the definitions and some of the concepts which have raised questions. And I want to be absolutely clear. I'm not going to try to be comprehensive because I cannot be comprehensive. What I identify there as difficult issues or difficult concepts are the result of my own experience. And then I will look at a case study on the SME definition. There is also a question about something else concerning how one defines an SME, but I'm happy to report that I have found an answer. I think I have found an answer, and I will tell you what my answer is, and then you tell me whether you would agree with that or not. So these are the latest known numbers. They go back to 2014. They were published in the scoreboard, which appears annually on the website of DG Comp. And they indicate the total amount of aid granted by member states in 2014. That's about a little bit more than 100 billion euro. That number excludes railways. Railways is the sector that over the past, I don't know, 10, 20 years has received the largest amount of aid. It's about 40 billion euro annually. And that sounds huge, and it is huge, but that's because many railway operators and bus operators operating under public service obligations, and therefore they are eligible to receive compensation. Now, the numbers in 2014 are kind of surprising because, again, if you look back over the previous decade, the amount of aid given to industry, manufacturing, and services, excluding railways, and excluding the aid that was given to banks as a result of the financial crisis, hovers around 60 billion euro. So in 2014, there was a huge jump from 60 to more than 100. Now, that is surprising. And there is an explanation on my next slide. The map there also shows the intensity, that's what I would call it, or the propensity of member states to grant aid because it measures the amount of aid in relation to GDP. Naturally, larger member states grant more aid. Smaller member states grant less aid. However, if you take it in relative terms, then the intensity of the color shows the share of aid in GDP. And you can see the variation in colors. And in my mind, ladies and gentlemen, that is the best explanation why state aid control is needed. Precisely because member states have different propensity, different tendency to grant aid, and therefore there may be distortion of competition. So it's not, in relative terms, it's not always that the large member states give more aid. Some of the smaller member states give significantly higher amounts relative to their size. This is the explanation for the jump in the numbers in 2014. It was off the charts, so I stole this graph from DigiComp. My apologies to DigiComp, but I had to type in this one because the axis goes to, I think, 10 billion, 16 billion, and this is almost 44 billion, so it's somewhere up there. And the significant increase in 2014 is accounted by the fact that a large amount of incentives have been given to generators of green electricity, green energy. So it's environmental and energy saving. But for our purposes today, here is regional aid, regional development. So in 2014, the amount, the vertical axis is 2014, the horizontal axis is 2013, so you can see the variation from year to year. So the amount given for regional development in 2014 is a little bit larger than 2013. And regional aid, if you exclude environmental aid, is the largest target for public policy granting state aid. Now, for SMEs, we are down here. So SMEs do not appear to be the major target, but I suppose a lot of SMEs would receive aid that would be classified as regional aid. So you have a problem of classification there. Now, this, for regional aid specifically, if you look at the last 3 years, 2012, 2013, 2014, then the total amount is about 15.5 billion. And the block exempted aid is about 10 billion. So it appears that indeed member states are using the GBR significantly. Now, the last figures I heard from DigiComp with respect to the number of measures which are implemented in member states, that was close to 90%. So 90% of all measures now, all state aid measures, not regional aid, all state aid measures are based on the GBR. So in this sense, the Commission has succeeded with its state aid modernization in inducing member states to use the GBR much more extensively. Now, the 90% figure is the number of measures. If you look at the amount of aid which is based on the GBR, then that's a little bit lower. I think that's about 70%, 60, 70% still. But the majority of aid now is given on the basis of the GBR. And as I said there, if you look at these numbers, about 2/3 of all regional aid is given on the basis of the GBR. So the GBR is your main instrument. With respect to SMEs, and also includes risk capital, the amount is much less. In 2014, a little bit less than 4 billion, and the block exempted was 1.6 billion. So in proportionate terms, the GBR appears to be less utilized for SME aid in relation to regional aid. And there I took the block exempted aid for 2014 and I compared it, regional aid, environmental aid, research, employment, and SMEs. SMEs comes aid for SMEs is in the 6th position, fifth position, sorry. Now, these are the numbers. So it's correct to be concerned about regional aid because loads of money goes for regional aid purposes. Now, where do member states appear to be getting it wrong on the basis of what the auditors have discovered? Now, the annual report of the European Court of Auditors, the latest report that was published in November 2015, identifies the source of irregularities. Now, an irregularity can be something which is a mistake, simple mistake, or it can be something which is very significant. They're all classified as irregularities. Where member states appear to be getting it wrong is in public procurement, a major source, the main source of irregularities, and state aid. With respect to irregularities in state aid, three things come out at the top. And then I went back and I checked previous reports of the Court of Auditors, and the same things appear again and again and again. Apparently, in about 1/3 of the audited measures, and I repeat, audited, that you need to extrapolate, and the amount of measures, the number of measures which are audited are naturally smaller, far smaller than the total number of measures which are implemented. So assuming that the audited measures are the same as the implemented measures, then there is a huge problem. Apparently, about 30% of all measures are implemented without concern with respect to the incentive effect of aid. And where, again, member states appear to be getting it wrong is when they give aid after the project has started. So we're not even talking about examining whether the company would have moved without the aid or would have started the project without the aid. This is the simplest of the violations, the absolute capital mistake here, where there is no rule, there is no state aid rule that allows aid after the project has started. And apparently, some authorities do make that mistake. The next problem is that aid is granted for ineligible costs. And the typical ineligible cost is operating cost. Most aid is allowed for investment expenditure, but apparently some companies are very good at hiding operating expenditure, and apparently, again, some public authorities do not check to exclude operating expenditure. And the third typical mistake is that aid exceeds the maximum ceilings. And probably this is, when you deal with structural funds, this is a mistake which is easy to commit, because with structural funds you have different ratios, different ceilings, and then you look at state aid, and then you have to comply with the ceilings defined by the state aid rules that may be different from whatever ceilings are defined by structural funds. So the third mistake is a mistake, but perhaps there may be an excuse for it. Now, that are the major problems discovered by or the overall problems discovered by the European Court of Auditors. The Court of Auditors has also undertaken special reports. Do not worry, I'm not going to go into each one of them. I simply mentioned them there in case you may be interested with respect to the implementation of financial instruments. For the period 2014 to 2020, the European Union will commit about, I think, 25 billion euro to support financial instruments. So we're talking about large amounts of money. But these reports provide for sober reading. Why? Because it appears, at least in the previous financial period, and I think now many of these problems have been solved in the present financial period, a number of member states set up financial instruments without having in mind well-defined policy objectives, without really knowing what is that they wanted to achieve. It was just a new fruit, money was available, well, they thought, okay, let's spend it. The other issue that has been discovered by the Court of Auditors is that, well, the beauty of the financial instrument is that it incentivizes private investors to go together with a public investor in an SME. That is the leveraging effect. It appears that the leveraging has been low or lower than expected. Again, aid was found not to be necessary. Again, the costs were ineligible. And again, there was failure to comply with maximum aid ceilings. So this is what the Court of Auditors discovered, and this is what I think you need to be aware of. Now, on the basis of, I turn now to the third theme of my presentation, which where are the difficult concepts in practice? On the basis of my own experience in working together with public authorities, it appears that so far we haven't cracked the meaning of the definition in Article 6 of the GBR, that when you give ad hoc aid to large enterprises, you have to ensure that that ad hoc aid has an incentive effect, and the GBR refers to material increase in the project, in the investment that is funded with public money. Now, what is material increase? So far, I haven't seen any interpretation, and there is this frequently asked question document, and so far, I think, unless I missed it, no member state has asked formally what is material increase. One can interpret it, significant, extensive, non-negligible, but what does that mean? 3% more, 5% more, 20% more? Well, okay. Then I'm very glad you mentioned the Dilly's Wellness Hotel, because a new question came up. Yes, member states have to respect the transparency requirements, but the previous GBR had a requirement which does not appear in the present GBR. The previous GBR required member states to tell aid recipients that the aid was granted on the basis of the GBR. The present GBR doesn't contain that requirement. So that after the judgment of the Court of Justice, I had a couple of phone calls from worried public authorities asking, shall we tell the recipients that this money is given on the basis of the GBR? My answer was, regardless of whether the GBR explicitly requires you to do that, do it. You lose nothing, and in fact, it's kind of an insurance policy. But there is no explicit requirement. One can infer, well, if you need to publish, if you need to refer to the registry number given to you by the Commission after you tell the Commission that you have implemented a measure on the basis of the GBR, then, of course, it comes down to telling the beneficiaries that the aid that they receive is on the basis of the GBR. But as I said, there is no such explicit requirement. In my view, you lose nothing by doing it. These are general issues. More specifically to regional issues, a question that comes up with unbelievable regularity is what is fundamental change in the production process. It's hard to interpret it. Over the past 5-6 years, I've seen only a couple of Commission decisions where this has been interpreted. One case I can mention is when a company used a different kind of fuel in the production, so there was extensive retooling of the production process. Okay, that is fundamental change. But how far can you generalize from that? The second issue is that Article 13 of the GBR says that you may not give aid to a company that closed down similar activity somewhere else in the EA, or intends to close down an activity in the next 2 years in the EA. How do you check that? If you ask the company will tell you, we have no intention. But how do you check that indeed they actually comply with that? Do you have to rely on newspaper reports? And are you going to read Greek newspapers in case they close down a plant in, I don't know, in Greece? And the third question is the diversification into new activity. And that relates to large enterprises that invest in C areas. As I'm sure you're aware, one of the biggest changes in the present GBR in relation to the previous GBR is that large enterprises are not eligible anymore for investment aid in C areas unless they do something new. So they're allowed for diversifying into a new activity, but if they diversify into a new product, they must notify. There is a wonderful decision of the Commission, very recent decision. The person sitting on my right has been instrumental in that decision, and I say that not to compliment him, but it's a very didactic decision. It's a textbook decision because it takes you by the hand and explains everything. So it's the decision concerning Hamburger Rieger. Am I pronouncing it correctly?
It's quite correct, yes.
All right. It's a paper manufacturer, and it's as I said, it's a very good decision if you want to see how you can structure your measure in case you want to give aid to a large enterprise in a C region. But still, the decision refers to new product. Now, what is new? We do have guidance. The rules say new is something which is in a different 4-digit NACE category. I did bother to go find the regulation that defines the categories of economic activity. And the title is economic activity. Fine. But then when you go into the specific categories, I give you an example. There is one category which says manufacturing of ceramic products. One number, 4-digit number. And then manufacturing of cement, a different digit, different 4-digit number. So if you go from ceramic products to cement, then it's a new activity. But wait a second. If you go from ceramic products to cement, that's a new product. So what's the difference between an activity and a product? I've had a number of queries on this point, and I have to confess, I'm not able to explain it. Maybe there is something there. Okay, I think we will explore it probably later. And these are the definitions in the GBR and the regional A guidelines. And I put them there because indeed you see, if you put them together, you see they're identical. And at the bottom, the top is for initial investment, the definition of initial investment, identical. Then the next row is the definition of initial investment for a new economic activity. And the big difference between the two is that initial investment includes expansion investment, where if it's a new economic activity, expansion investment is excluded. That's the main difference. And then at the bottom 2 rows, I put the definitions for aid by large enterprises in C regions. So the GBR's Article 14 says that aid may be granted only for a new diversification into a new economic activity. Paragraph 15 of the guidelines saying that eligible aid can only be for diversification into a new activity or for establishing new products or for new process innovations. So, and in the Commission decision, which I mentioned, there is, again, a very good explanation that tells you, in fact, we have two notification requirements. Either aid exceeds the amounts, the thresholds, or is for a new product or a new process innovation. That means that you also have to notify. But I repeat here, I wouldn't be able to make the distinction between new activity or new product. Okay, with respect to SMEs, the difficult issues, there aren't many difficult issues, I think, with respect to SMEs, but some of the generic issues appear here again, as for example, what is fundamental change in the production process? I would jump to the third point, and then I would come back to my second point, because I have an answer to the second point. The third point is that I also looked at risk finance, Article 21 of the GBR. Article 21, paragraph 13 says that all financial instruments have to go through a financial intermediary. And a question that has been put quite often to me, and I have an answer, but I'm not quite sure whether my answer is correct. If you look at the Common Provisions Regulation of Structural Funds, that is Regulation 1303 of 2013, Article 38 says that for financial instrument, member states can either implement at EU level, so they give the money to EIB, EIF, or they implement via financial intermediary, or with respect to loans or guarantees, they can implement directly. So they can give a loan directly. But then the GBR tells you, no, you have to go through a financial intermediary. So must we assume that the legislator was schizophrenic and the legislator didn't know what he was doing? I think not. That should be the wrong conclusion. The only conclusion I would draw, which allows us to consider these two provisions as consistent with each other, is that if you give a loan directly, that loan must, any aid which is contained in that loan must be de minimis aid. So it's not captured, it does not fall it's not state aid, so it doesn't fall within the scope of the GBR. That is the only consistent interpretation, but appears to create a conflict between the two. Now, with respect to the definition, we will come back to this issue of definition. Because now structural funds support, one of the themes which is supported by structural funds is research, and because universities across the European Union are suffering from budgetary cuts, they have tried to find new sources of income, and that is commercializing the knowledge they generate. So they create spin-off. There is no doubt that the spin-off or the joint venture with industry is an economic activity, although some universities have tried to argue that it's not. In my mind, they are wrong. It is economic activity. But the spin-off is one professor, one assistant, and maybe, I don't know, endowment of 1 million euro. So it appears to be even a micro enterprise. So the question is, can they benefit from the SME bonus if they get, for example, aid for experimental development or industrial research? I talked about this with my colleagues, and we looked at the annex, the SME definition in the annex of the GBR, and it refers to enterprises. So the lawyers of this particular university came to me and said, Professor, you are wrong. Because I said, this university is very large by the SME definition. So something which is owned by the university, to me, seems also large. But they said, well, the SME definition refers to enterprises. And they were right. And of course, there is also an explicit exception when it comes to partner enterprises. But there is an exception to exception that says that the exception for universities with respect to partner enterprises doesn't apply if the holding exceeds 50%. So I put there 51%. Well, I should have read more carefully, where is it? The SME, the document of the SME definition from DG Enterprise at the time, now DG Grow today, because I think page 29 has a specific example. And it says explicitly that if the spin-off or the joint venture is owned by more than 50% by a university, it ceases to be an SME. So it cannot be eligible for the SME bonus. So I think on this point there is clarity, at least in my mind. Okay, and then lastly, I want to look into a case study, a recent judgment, 2 years ago, judgment of the Court of Justice, where there was this company, HTFO, which owned another company, well, had links with another company. What I have done, here it is. Here is the one company. Has two shareholders, A and D, each one owning 50% of company X. But it so happens that D is the mother of A and B is the wife of A. So together, the son and the mother have 100% of company X, and A and B, as far as I know, they were not divorced, so they were still sleeping together. So together, they also had majority shareholding in HTFO. So to cut a long story short, they were claiming, in fact, that X was an SME, which was not true because it was controlled through natural persons, and the court said, sorry, let me go back. The court said something which I thought was very wise. The SME definition must be interpreted on the basis of its aim, not on formalistic grounds. And the aim is to identify enterprises that suffer from an economic handicap because of their small size. That is why EU rules allow bonuses for SMEs. So, if these links give together, the links between natural persons, they give them an opportunity to work together, to exercise influence over the commercial decisions of other companies, then of course, all the companies over which they can exercise influence should be counted together, because they form a single economic unit, and the single economic unit, if it's large, it doesn't suffer from the handicaps which are identified for SMEs. So the moral of the story here is that one has to look beyond the legal formality and identify who controls the company. I suppose this would be a problem in some countries where there are many informal links between companies, and companies are owned by a wife and a husband, or children and parents with different names, and they appear on the register of companies under different names, and then you have to piece the puzzle together. But that the law, I suppose, is clear that the obligation of the aid granting authority is to ensure indeed that the rules are not bypassed or circumvented through formalistic means. And I think that's about it. Thank you very much.
Thank you, Professor Nicolaides, for taking us through, let's say, the real life experience, and it also shows that some of the basic principles which are written down in our regulations, it's not always easy to interpret it in daily life. And some of the topics which you brought up will also come back in the workshops in the afternoon. For example, the SME definition, we have organized a dedicated workshop on to this. We are at about of the coffee break, but I still would like to use and give you the opportunity to ask questions to both our speakers who have been setting the framework for the rest of the day today. Are there any people who have questions or would like to make comments to the presentations made?
Hello.
Yes,
Hello. Julie Tirant from DG Regio. I would like to ask, please, to Klaus Otto about the cumulation rules. If I remember correctly, it was per beneficiary. But now we talk about eligible costs. Can you please clarify? Well, do we agree that cumulation rules is that you look really per beneficiary? Is that really the criteria?
Yes, cumulation rules apply as to the economic unit, which is normally the group or in most cases an individual undertaking. The cumulation rules in the GBER are organized in a way that they say, if you have a specific project and aid goes into this project, which is block exempted, it can be combined with other block exempted or not block exempted aid for the same project and for the same eligible cost up to the maximum aid intensity ceiling that is defined in the GBER for this type of project. If the project should be run by different undertakings, which could be possible, you would have to take the project as a whole and to see what the aid as a whole gives in terms of combination of measures with respect to the allowable aid intensity calculated over the eligible expenditure incurred by different undertakings for the same project. Does this help? I'm not sure whether this was a question.
So you could have, for example, one project that would be linked to different different parts of the GBER. For example, it would be regional aid, it would be for environment and energy, and it would be, I don't know, it would cumulate different ones, and then you would sum it up, but you wouldn't have to, you couldn't overpass the threshold?
No, I understood your question differently. I understood the question as meaning, let's say we have one project which is interested by two companies together that might have an interest in having this project together. Maybe even related undertakings, who knows. The investment project as such cannot be separated for whatever reason. Could be possible. It is possible that both undertakings ask for have a joint aid application, or they may even be asking for introduce separate aid applications for the same project and their respective parts in it. In this case, what has to be done from a stated point of view is to ensure that the overall aid amount with respect to the overall project cost doesn't exceed the ceiling. Your question was a different question now. What happens if different articles of the cheaper could come into place. Let's say an energy efficiency measure which could benefit from each region aid, but which could also benefit from energy, from environmental aid. In this case, insofar as eligible expenditure is overlapping, the maximum aid amount, maximum aid intensity for the overlapping amounts of eligible expenditure that can be granted is the highest aid intensity that is defined by the cheaper in the more favorable article.
Okay, any further questions, comments at this moment? Yes, please. Maybe if you
Hello, I have a question concerning combining the minimis aid and GBR exempted aid in one project. We have in our state aid schemes provided the situation then that for one project we can give regional aid or any kind of other aid exempted on the basis of regulation, and the minimis aid, but on a different eligible costs. And is it okay, or is it a kind of I don't know how to say. Is it okay? Or maybe I will stop in that point. So we have combined two types of aid: state aid based on GBR, and the minimis aid, but on a different cost. For example, we included in the minimis costs such costs as worker delegation, operational costs, and so on.
Let's not speak of eligible cost, let's speak of two passing tubes. The first passing tube is already filled with water which represents regional aid. There is no further drop that fits in. If you fill in your de minimis water into the already filled water tube, it flows over, the ceiling is exceeded. If you fill in the water into a different passing tube, nothing happens. No ceiling is exceeded. So insofar as the de minimis aid is granted for different eligible cost, there is no problem. And the best thing, of course, is the de minimis aid is granted without any eligible expenditure being defined. Michael?
You have to speak close to the microphone.
Okay, so thank you for the explanation. That confirms our position. Thank you.
Okay, then I think we probably close this session and then we have our coffee break. So first, thanks to both Klaus Junge-Dietl and Professor Nicolaides for their contributions, and they will stay also for the rest of the day, and Klaus will also be moderating one workshop this afternoon, so you will still have enough opportunities to ask your questions. So thank you to both of them, and see you at 11 o'clock again in this room for the second session.